All right. Well, welcome everyone on behalf of all of your area chambers of commerce and the Lakes Area Human Resources Association. My name is Matt Killian. I'm the president of the Brainerd Lakes Chamber. Especially want to thank our partners in Pequot Lakes, Cross Lake, Nisswa, and Cuyuna Lakes, and all the members of those chambers who are with us today. You likely know quite a bit about area chambers due to your memberships. I wanted to quickly introduce Tony Giamona. He is the president of the Lakes Area Human Resources Association that you may not know as much about. And so I'm just going to invite Tony to share a little bit more about their organization. So take it away, Tony.
Excellent. Thanks, Matt. Appreciate the opportunity. Yes, I'm the current president of the Lakes Area Human Resource Association, better known as LARA. We were established in 1999, and we're a group of 94 human resource professionals across the Brainerd Lakes area and a chapter of the Society for Human Resource Management, or SHRM. Our mission is to be recognized as foremost HR leader for resources, education, and development of human resource professionals in the Lakes area. And so we do different programming and promote professional development and networking, provide members opportunities to get continuing education through some of our programs. And we appreciate the opportunity to be here with you today.
All right. Well, thanks, Tony. I really appreciate you partnering, and you'll see more of that in the future as some of these laws are enacted. We love to partner with LARA to bring you this information. As all of you know, in the 2023 legislative session, the legislature passed several laws governing, the labor employer-employee relationship. You may know that the chamber came on the other side of a lot of those issues and looking really to support preserving the relationship between small businesses and your employees, and trying to make sure that the HR and PTO systems that you have intact and engineered for your companies remained what they are. So we're not, at this point, we're not going to debate the merits of the system. We want to bring you the good information that you need, the timely information that you need to comply with the new laws. And so on January 1st, 2024, what we're talking about today is the Earned Sick and Safe Time Law. And that's going to require you to either adapt or enact a new PTO system to provide sick and safe leave using an accrual system that our presenter will talk to you about today. This is not to be confused with the paid family and medical leave law that, Dave, maybe you can address briefly, that will be enacted in 2026. So I really appreciate the Minnesota Department of Labor and Industry being with us today. I commend them for working with local chambers. Dave shared with me that you've done more than 30 of these webinars throughout the state, and we really appreciate you being virtually in the Brainerd Lakes area today. So I'm going to introduce Dave Scoveholt. He's with the Minnesota Department of Labor and Industry. He'll be our presenter today. We will take the questions throughout. You want to type those in the chat. If we get a number of them, we'll take them also at the end as well. So thanks again for being here with us today, Dave, and I'll turn it over to you.
Great. I am going to just start sharing the screen right into it. And thank you so much, Matt and Tony and Colleen and all the chambers for the invitation this morning. Really appreciate that and appreciate everybody being here. I'm sure this is the number one thing you'd like to be doing in the morning, but it is a new law and it's important information. We're going to review Earned Sick and Safe Time. I'm happy to take, like Matt said, I'm happy to take questions, and I'll do my best to answer questions. I can't possibly answer every question, but I'm going to give you all follow-up resources, ways to get in touch with the department, ways to find FAQs on our website. Some of your questions may require some type of legal advice at some point. based on kind of getting a recommendation of what maybe is a best choice for you all. But we'll try to point you in the right directions as much as possible. All right, so earned sick and safe time. Yes, it is a new law that was passed in the 23 session, and it is starting January 1, 2024. So this presentation, I'm going to go from big picture, and we'll cover the details as we get further into it. So the Department of Labor and Industry, we're an agency, state agency like all other ones, and we have different divisions. So we do interact with you all as employers in many different ways. And I'm in the labor standards division, but we also have workers. We oversee the state's workers' compensation system, the OSHA system. We have workforce development programs, including Apprenticeship Minnesota, Youth Skills Training, and Dual Training Pipeline. Those are great programs that can help you find and retrain your own employees. So those, I would encourage people to look into those. We have other divisions as well. So what is labor standards? Labor standards is essentially the state's wage and hour division. On the federal level, there's the Department of Labor. They include the wage and hour division. We call it labor standards in the state of Minnesota. Many other states use that term as well. And what does that cover? So you can see these are the main laws that we oversee. So the Minnesota Fair Labor Standards Act is our minimum wage and overtime law. The Women's Economic Security Act is the law that governs the laws related to pregnant, new parent workers, parental leave as well. Child labor laws, what types of environments youth workers can work in, working hours. Prevailing wage relates to state contracts, mostly for construction, and wages that would be required to be paid when work is performed under those contracts. The Wage Theft Prevention Act, that was a very recent one that was passed in 2019. So there was a number of changes there you all may be remembering. And then other laws, and that includes earned sick and safe time starting January 1st, 2024. So as Matt said, there was a number of changes at the 23 session. Maybe a lot of us are familiar with these, but I'll just do a quick review because there was such a significant amount of change that it's hard to kind of track it all. So the first two things here, the earned sick and safe time, as well as, well, really the first three bullet points, the earned sick and safe time, pregnancy and nursing accommodations, and the family paid and unpaid leaves. So those do impact all employers across the state, regardless of industry or size. Those are going to be all industry changes. They're phasing in at different times. So as we've talked about with earned sick and safe, that's January 1 of 2024. Pregnancy and nursing accommodations, there was an expansion in the ability of employees to have access to those accommodations, including in their first year of employment. And those started on July 1st of 2023. So we do have good resources about that on our website. We have some recorded webinars as well if people want to look more into that. The paid family leave, paid family medical leave, starts in 2026. And it is a point of confusion in terms of that and earned sick and safe time. They're both different types of leave people can take from work that would have a pay compensation system. Earned sick and safe time is for short-term leaves. It's going to fall into more of your kind of PTO style, sick time style benefit that employers currently offer. Paid family medical leave is the longer-term leave for more serious longer-term medical issues or childbirth and parental leave. And that, again, starts in 2026. It's going to be run very similarly to the unemployment system, where there's an employee contribution, there's an employer contribution. The Department of Employment and Economic Development, a different agency than where I work, is going to be administering that program. So those payments will be submitted to DEED, and they will administer and distribute the leave, the payments to employees when those leaves, when it's appropriate or when it fits, when they have the leaves that fit into that program. So I know there'll be a lot more to come on that in the next couple of years. It's a very big program, and I'm sure that you all will have probably another session covering that at some point. Unpaid leave was also expanded. So I've talked about that the nursing and pregnancy accommodations are now accessible in the first year of employment. So is unpaid leave. The state parental leave law is something that's kind of a little bit under the radar because it's similar to the federal Family Medical Leave Act, FMLA, but now it's expanded. So you may come into contact with that at some point because more people have access to it. So again, we have resources on our webpage. There's the rest of what's on here, or most of the rest of what's on here, is specific to certain industries. So there was a number of changes that relate to meat packing and poultry processing. The ergonomics program was included there, and other protections for employees that are in those industries. And then Nursing Home Workforce Standards Board, if you're in that industry, would encourage you to look that one up as well. And the Construction Worker Wage Protection Act relates to potential liability of general contractors if their subs did not pay wages on a job. So those are, again, a number of important things good to look into if you're in those industries. All right, let's get into the main topic. Why earn sick and safe? This is kind of just a reminder of what why this law was passed, why the legislature decided to pass this law. So like any sick time availability or benefit, it does allow people to take time off for care reasons if they have personal or family care, and not to have to lose their job because of taking that time off. It does help move us as a state in a more preventative care mode and reduce illnesses from spreading in workplaces, in schools, and those types of settings. And it is something that is going to be across the board in terms of all employers, as we talked about, which does mean from an employee standpoint that regardless of the type of job somebody has or their income level, that they're going to have access to this. So that really broadens out the amount of employees, the employee side, access to this type of leave. These types of programs have been seen to increase the ability to recruit and then to retain workers over time. So hopefully that's something that is a benefit for you all as employers as these laws get implemented. And then additionally, so you all may be familiar with this, but in Minneapolis, St. Paul, Duluth, and Bloomington, there are ordinances that require a very similar benefit, very similar earn sick and safe time program. So really what this does is it expands out from what those cities have been doing. And I believe Minneapolis was first enacted in 2017. 14 other states have done this as well. So there are some models out there, and I know that employers sometimes have been looking to like industries or like employers, or if they have a branch or location in another state, kind of how did you implement this? How did you work through the beginning stages of when your state or city had this type of requirement? So big picture again, here we go. What does this essentially do? It moves us from a state that has, and we've not had until this point, there's no paid time off requirement. So if you're working for an employer of any kind, the benefit of paid time off, whether it's vacation, sick, PTO, whatever the name of the program is, that's been an employer optional program. On January 1st, that changes. There'll be a paid time off requirement for if you're working in the state that to receive paid time off. We'll talk about more of the details there, but that's the big change. No paid time off to a paid time off program. There is a current sick and safe leave law, and it essentially requires that if an employer does offer sick leave of some kind, that the employee be able to use it to care for family members, as well as use it for the safe reasons, and we'll cover what that safe means in the next few slides. Okay, so that's the big picture. What is it? What is sick and safe time? It essentially is caring for yourself, the ability to take time off of work and be paid to care for yourself, to care for a family member, and then thirdly, to if the employee is experiencing or a family member is experiencing domestic violence or abuse or sexual assault, that they're able to take time off to address that as well. Who's eligible? Kind of talked about this as an all-employer impact law. So when I say that, what does that mean? It means that any employee that's working at least 80 hours in the state of Minnesota annually is going to be eligible for this, to accrue time and potentially to take time off under this law. So this includes short-hour employees. Employers use different terms. It could be temporary, it could be a seasonal employee. It depends on how long that employee is with you, of course. Part-time employee, but as long as they're working 80 hours annually in the state, they will potentially, they will accrue time and potentially be able to use it. So it's broad. All right, how much time can employees earn? So this is kind of the basics, and I know that probably most people are familiar with this. We'll get into more of the details, but it's at least 1 hour for every 30 hours worked. So employers could certainly have a program that's more generous than that, or earning at a higher rate. And I know one of the main questions employers have is, well, how does this law, the requirements of this law work with my current program, my current PTO program? But at least 1 hour for every 30 hours worked, and the employers can cap that amount at 48 hours in a year. So if my accrual year starts January 1st and I'm working full-time 40 hours a week, sometime in the early fall, that's when I'm going to reach my 48 hours, assuming I haven't taken any time. So that's kind of the time frame. At that point, my employer could say, that's it. That's all you're going to earn for the year, and we're going to cap that amount. So it's not, the 48 hours is not kind of on a 12-month calendar in terms of how fast it can be earned. It could be earned potentially earlier than that, but at that point, the employer can cap that amount and stop accruing for the employee. All right, so who are the family members included? So we've talked about that it's care for yourself, but it's also being able to take time off to care for certain family members. It's a pretty extensive list. You can see here, it says it's a broad set of family members, and that's why I don't have it on the slide, but it essentially includes, and the most common thing I think people are going to think about is taking time off for your own child, but it could be that you're taking time off to care for an adult child, a spouse, a sibling, biological or adoptive child, grandchild, grandparent. It's quite an extensive list. So you can see the full list on our webpage. But that is something when you're thinking about, well, how do I make this program work with what I'm currently offering? This is one of those areas where you'd say, am I allowing my employees to take time off to care for the same list, the same group of family members? That's falls under the state law. Okay, what can sick and safe time time off be used for? So I kind of talked a little bit about this. Now we're going to go into more detail. So there's the kind of foreseeable and unforeseeable use. So foreseeable is those times when you're asking for time off in advance because you have a preventative care or a treatment. Maybe you have an ongoing medical condition and you have a regular treatment appointment. So those things, when you know in advance, you're going to be needing time off. for those preventative care appointments. So it's not just the immediate need where I need to call in sick. I woke up this morning and I can't make it to the webinar. I'm going to call in. It's not just that. It's also that you can use it for foreseeable or preventative treatment care appointments. Same thing with family members. So, imagine your child, most common situation, you're going to take time off from work because your child is ill and they need somebody to care for them during that time. Or it could be that that family member has that treatment appointment, that preventative care type of appointment. So those two, yourself, your family member, kind of those, it can be a mental or physical illness, as we see here on the screen. So it is quite broad in that sense, that it's different types of issues are covered there that people could use the time off for. The third bullet point covers those safe time reasons. So domestic abuse, sexual assault, stalking, could be that the employee is taking time off to see a service provider, to go to a court date. Potentially they're working with the police. There could be a number of things. Hopefully that person is addressing those issues, getting themselves in a better place. But that part of the law allows that employee to take the time off to address those issues and be able to have compensation for taking that time off. All right, the fourth bullet point is where we've had the most questions, so I'll kind of review it in pieces here. And it's closure of the employee's workplace due to weather or public emergency. So a couple things there. This is the individual employee's workplace. So as we can imagine, lots of employers have multiple locations, or they may close part of their operation, part of their business due to weather, but they may keep other parts open. So it's really going to be dependent on the individual employee's operation. I work in the St. Paul office of the Department of Labor and Industry. Let's say 2 feet of snow drops, and they close the St. Paul office. But Rochester didn't get any snow, so Rochester office of the Department of Labor and Industry is going to stay open. Those employees would still be able to go in. Now, I'm probably going to be working at home remotely, but not everybody has that choice. So again, if it's closed because of weather, that could be in the individual employee's workplace, that could be a reason somebody could use earned sick and safe time. If the employer closes because they're a restaurant and they don't open on Mondays, or it's the weekend, or it's a holiday, or it's a seasonal business and they're not open for part of the year, those are not reasons why the employer would need to offer earned sick and safe time or any type of paid time off. They could certainly do it on those days, but it would not be required under the law. So again, that's the first part. The second part is closure of a family member's school or care facility. So the care facility, think daycare, childcare is probably the most common type of situation there. Again, due to weather or public emergency. So sometimes those places close. It's not always because of weather or public emergency. So that would be the reasoning that somebody would be able to use the time off. So the last one is kind of the pandemic related one, and that's if a health authority or healthcare professional has determined that somebody could infect others if they go into the workplace. I imagine they probably aren't feeling well, and so it might fall under number one if that's the case, but that's another reason somebody could potentially use this time off.
Dave, we have a number of questions in the chat related to the accrual system. I think you're going to get to that, so I'm going to save some of those, but one that has to do with the topic you just talked about.
Yeah.
Is if an employee works from home and has an internet or power outage, would that be a reason to use sick and safe time?
So an employer could certainly allow it, but unless I guess I would say, did the employer close that location because of weather? that's possibly be up to the employer. If the person needs internet to be able to do their job and the storm knocks out the internet, possibly the employer says, you can't work today. That's not going to work. And it was the storm knocked out your internet, so we're going to allow you to use it. But generally speaking, no, they would not need to use the time that day.
And thank you for that. Another question regarding weather. Can the weather emergency be called by the company, or just if the individual employee says that weather is an issue?
Yeah, that's a good question, and one we've had. So it is the employer that makes that decision whether to keep the operation open or not. It's not dependent on whether the employee can get out of the driveway if there's a storm, or if they have, of course, some employees live farther away from their place of employment than others, and there is difficulty getting through our roads sometimes. But it really is the employer that is making that decision about closing the operation due to weather, and not dependent on the individual employee's ability to kind of get to that location. Again, employers could certainly allow people to use it. It can be more generous than these requirements, but that would not be required.
All right, thanks. And I know, and I do see some of the other questions in the chat. I'm going to let him get a little bit further, and then we'll ask those at when he gets to those sections. So just stay tuned. Thanks. Go ahead, Dave.
All right, great. So let's now, again, we're getting into more of the details here, and we're going to talk about the rate of pay. So this is probably going to be similar to those of you that are off, that do have paid time off programs already. You probably already have a pay system, how you compensate them. And I'm guessing it's very much in line with how the state law works. But just a brief review here, that it's essentially you're compensating the person for the same rate of the same hourly rate that they would have earned if they would have come in that day or that shift or that time that they missed. So sometimes this can be a little complicated when you have somebody that works in multiple job classifications. So restaurant example, you may have somebody that works as both a dishwasher and a cook, and it's just determining which shift they were going to work, which shift they missed, and what position they would have been in. So it's essentially replacing the wage for that day that they would have earned. There are lots of types of wage rates that are variable, that are not kind of a set straight hourly rate. So it could be a piece rate. It could be paid by the mile if it's a driver. There's different types of, certainly lots of different pay systems. What an employer could do in those situations is basically make a determination of their best determination of what the person would have earned. So like taking, for example, the last 3 paychecks and looking at the hours worked and dividing that out and figuring out what the hourly wage was. It could be that they're looking at other people that worked in that classification the day they missed and what they earned. At the end, the employers need to pay at least minimum wage for the time that the person is out. So gratuities are not something that employers have to compensate people for missing gratuities. And then additionally, another question we have had on related to this is related to overtime. And that's if the person's shift, let's say that the person is scheduled for 6 days. And so they're scheduled into an overtime shift. And let's say that they miss that overtime shift. One of the questions we've had is, does that mean that the employer needs to pay the person time and a half for the time for that day because they would have earned overtime? And the answer is no. The law does not require that the employer pay overtime in that situation.
Another question related to that, and I'm trying to monitor everything here.
Yeah.
How do we handle sales people who are paid on a commission basis?
Sure.
Is the commission included in the wage, or is it just the hourly?
Yeah, so I'm guessing a commissioned employer, this is a question we've had, and commissioned employers probably have a system for kind of how they pay PTO generally. This is one where, again, the employer could kind of create a system or a formula. The law didn't do that for us. So they didn't make that system establish that. But essentially, if it's a fully commissioned employer, it's possible the person would receive at least a minimum wage on that day, but the employer could create a system to kind of determine what the person might have earned if they would have come in. All right, so I mean, and related to that is salaried employees. So of course, that's another one where the employer could, especially if they're a salaried exempt, professionally, administratively, those types of exemptions, the employer can kind of use a 40-hour work week and divide that out and figure out an hourly wage. So talked a little bit about this earlier. There's the city ordinances. There's as well the your own paid time off programs. I'm going to skip the city ordinances. I'm guessing that does not apply to people here in this session. Paid time off programs. So this is where, again, and we're going through more of the details in the slides that continue, but does your program now, so I guess a step back would be employers want to know, how do I make this work with what I'm currently offering? Because I don't necessarily want to offer more time. I believe I'm already offering enough time under the law. How do I make sure that I can kind of marry my program and the state law requirements and do it that way? And essentially what that means is, am I offering enough time? Am I offering at least 1 hour for every 30 hours worked? Am I allowing people to take it off for those reasons that we covered earlier? Am I allowing people to use it to care for the same list of family members that are included in the law? There's a number of other things that we're going to be covering, and it's kind of like putting all those together and offering at least the amount of hours that are required under the law under those terms and conditions. If employers would like to offer more hours than that, and certainly many do, or many do for parts of their workforce or groups of their employees, they certainly can, and they can certainly have their own policies or practices around the hours that are beyond what's required in the law. Okay, so here again, we're getting into more details. So earning statements, this is one, there is some changes to what would be required on check stubs, pay stubs, earning statements. So employers will want to check with their payroll provider, their software programs, or whatever system you're using to produce those earning statements. And there's two things that will be added to earning statements. Some employers already have this information, but this will be universal. So it's the amount of time that I have available to me. So let's say that I am starting to accrue on January 1, and I reach July and I've accrued 30 hours. So my pay stub will reflect, Dave, you have 30 hours available to you, in some format. It'll be there. Secondly, and then let's say that next pay period, I end up having to take a day off. I'm out sick. So I've taken an 8-hour block of earn sick and safe. So that next pay period, the second thing that will appear will, in addition to the total number of hours I have available to myself, will be the number of hours I used during that last pay period. Now, most of the time, I think that's kind of a line item in your payment section on the earnings statement. So that part is probably covered. The first part, in terms of the total number of hours available, I know that's something that less employers currently have on their earnings statements. So kind of figuring out how to get that in place is something that I know that employers are kind of spending a little time looking into and creating that system or working with payroll providers on. So that's the first bullet point here on the slide. Second bullet point.
Dave, I'm gonna interject just a couple of questions, sprinkle in these as we go.
Yeah.
Is the 12-month period identified as 12 months from when the employee began employment? Example, if someone started July 1st, is his 12 months on a calendar year or a year from July 1st?
Sure. So great question. So it's kind of in this law, it's kind of puts the 12-month period is what we're calling the accrual year. So it's basically that year that you can earn up to the 48 hours. So the law does start January 1st, but essentially the employer can so I guess you've got to have to bring together a couple things, but employers can establish what the accrual year is for the employee. So it could, lots of employers are using calendar year. Some employers are using anniversary date of the employee. It's probably going to be whatever system, and you're going to want to, most employers want to kind of use what they have going and make the minimal changes. So if employers are using a employee anniversary date or a calendar year, or if they're using some other type of year, fiscal year, for example, they might do it that way. But as long as you're offering, and we're going to talk about the accrual as well as front loading options, and that will probably kind of influence how you make these decisions. But the employer can establish what is the 12-month accrual year.
Okay. And then one more, can an employer require any kind of documentation after a certain number of days, for example, 3 days for medical leave, or is that all just based on what an employee tells you?
Sure. Yep. There is a part of the law that talks about documentation, and it does at the point where the person is out more than 3 consecutive days. At that point, the employer can request documentation. That is on one of the slides I have coming up, so I can go a little bit more into it there, but yeah, it's that.
Sounds good. I'll save a few more of these till when you get to those slides. So thank you.
Okay, great. So the second bullet point here on this slide is the employee notice. And this is similar to the concept of a minimum wage poster. It's a way to inform employees about the law, about their ability to have these rights or protections, and what is available to them. So the employee notice is different from a minimum wage poster in that it's not something that you necessarily need to post in a common room, but it is information that employers will deliver or give to employees about the law. And you can give it to employees in different ways. You could email it to them if you have it, or have through an electronic system. If you have that type of system or that works best for you, you could give it out as a memo or a piece of paper, or put it in with paychecks. You could put it in an employee handbook. You could put it in new hire packets, whatever kind of system works best for you to distribute this information. But kind of the law puts forward, the employers should give a notice to employees about this law, and there's certain criteria to be included in the notice. First, before I go kind of through some of the criteria, I'll just say that we have a sample notice that we're posting on our website. I know it's finished right now, and it will be posted in the next few days. So that will be up, and employers can take that notice and either use it the way it is, or they could, you could make changes and put your own letterhead on it, or put it in a way that fits into your handbook, or merge it with some type of request policy that you have to kind of put all that together. So that sample notice will be available. What is included in the notice is things like the amount of time the person can accrue on a yearly basis. So if you're using the state law requirements 1 for 30, or if you have a different system, what the reasons people can use it for, the family members that people can use it to take off for, and there's a number of other things, but it's really the basics that we're covering here in this session. Okay, so here's probably the area where we get the most questions on, and we're going to cover the 3 different options. We've started talking about the accrual method, which is at least 1 hour for every 30 hours worked, and employers can cap that amount at 48 in an accrual year, a 12-month period. With the accrual method, there is a carryover provision. So if I, as an employee, earn 48 hours in 2024, and let's say that I use 40 of those hours, now I'm in December of 2024, I'm going to carry over 8 of those hours into 2025, and then I'll be able to start accruing again on top of those 8 hours. Once I get to 80 hours, and in my example, I'm not going to get to 80 because I've only carried over 40. But if I was carrying over more, I might get to 80. At that point, employers can stop accrual and can cap that amount. So once you get to 80, they can cap that amount. The provision still is there that somebody can earn up to 48 in a year. So potentially in that year 2, maybe I'm going to use some of my time. So now I've fallen under 80. I haven't reached 48 in that accrual year. So maybe I would start accruing again. That's a bit to track for the employer, is figuring out how to track that, that system. But that's the accrual method. So that's one option that employers have. Employers also have 2 other options. And as we go through this option, it's important to say that employers could use one of these options or methods for part of their workforce, for a group of employees, and they could use another method for a different set of employees. So I know that something employers I've heard talk about is, well, we're potentially going to be doing front loading for our longer term full-time employees. And for those that are in their first year or part-time situations, we're going to be using the accrual method. And so again, it's kind of, I'm sure there's pros and cons for you all as employers to pick out here which of these options are best, but you can use multiple options for different groups of employees. So option 2 is I'm going to front load, make available those 48 hours right at the beginning of the accrual year. The employees can use it as needed, and then any unused hours will be paid out at the end of the year. So going back to my example earlier, I have accrued 48 hours. I used 40. I've reached December. So in that scenario, my employer is going to pay me out 8 hours at the end of 2024, in December of 2024. And then in January of 2025, they'll front load or give me access to 48 hours again. So that's option 2. Option 3 is don't want to do payout, don't want to do carryover, no tracking, use it or lose it. I'm going to front load 80 hours. Employees have access to that throughout that accrual year. If they use it, they use it. If they don't, they don't. And then we will just front load again 80 hours. So that's option 3. Here's a spot where I like to, kind of go through what scenario that we get a lot of questions on, and that's employers that have more generous plans. So employers that have PTO plans, for example, that you can use the time off for any reason or almost any reason. It's common. Lots of employers have those types of plans. If the person, let's say my accrual year is the calendar year and my employer front loads me either 48 or 80 hours. And let's say that in April, I'm getting burned out of winter, and I say I gotta go south and take a trip. That could be part of the employer's plan that you can use it for any reason. So see if somebody's using it for that type of vacation reason. And then the question is, well, later in the year, let's say it's this time of year, somebody comes down with a seasonal illness and they can't come into work. Well, what is the employer's obligation at that point? Because the person had used it for vacation time. So at that point, the employer had already provided the time. The employer had made it available that the employee could use it for earned sick and safe time reasons. The employee chose to use it for the more generous vacation reasons. The employer has no additional obligation at that point. So they've met their requirement under the law. We don't have to force people to use it for earned sick and safe time. If you have a more generous plan and somebody decides to use it for one of the other reasons that you allow them to use it for, that was their decision. Okay, so, and I see the questions piling up. We're getting close to the end, and then I know we're going to run through those. So notice of use, foreseeable or unforeseeable. Talked a little bit about this earlier, but employers that want to ask people in advance if they're going to be using the time off, which I'm sure most of you would. You want to be in the know if somebody's going to be out. It's important that you have a policy, a written and a clear policy that employees are aware of how to inform the employer that they're going to be needing the time off. And probably that's going to be for those appointment or treatment types of situations. But that would be the foreseeable use. If the employer doesn't have a plan, then under the law, or excuse me, it doesn't have a policy or a very clear policy that employees are aware of, then they wouldn't be able to ask for advance notice. So that's important. It is also important to kind of, I guess, also add here that if it's foreseeable, the employer cannot require more than 7 days advance notice. You could certainly ask for it, and I'm sure that you all would like as much notice as possible, but you can't require more than 7 days advance notice. Unforeseeable is those I'm calling in that morning. And again, what's the process procedure? Probably something you all have established already. Who do you call? Who do you text? How do you notify the employer you can't come in that day, for example? We talked a little bit earlier about this documentation. So if the person is out more than 3 consecutive days and using earned sick and safe time, at that point, the employer can request written documentation to substantiate, to talk about what is the reason that you are out. So at that point, so if the person is out for 1 or 2 days, they wouldn't be able to request that documentation. Replacement workers, probably an issue that's it's for some industries more than others, but if somebody's going to be out and using earned sick and safe time, they can't be required or told that you can take the time off, but you have to find somebody to replace yourself. So that can't be a requirement. The employer cannot require the person to find somebody to take their spot. And then I believe this is the last slide with information about the law, and then I'll just share a little bit about our resources, and then I know we can go into questions. So increments of time. This one is, there's 2 sides of this. First is the accrual method. Let's say you're using the accrual method of at least 1 hour for every 30 hours worked. To make clear that those are 1 hour blocks. So the employer does not have to credit somebody with, like, for example, 0.5 hours of earned sick and safe time if they only worked 15 hours during a pay period. So you can wait till a 1 hour block has kind of been earned before it's posted on that pay stub, and then the employee would have access to it. Employers can use, if they want to do 0.5 hours, if that's easier for your tracking system, certainly you could do that, but it wouldn't be required. That's the accrual part of the increments of time. The other side is the use. So another provision in the law relates to the employer's timekeeping or payroll system, and that employees would be able to use the time off in the same increments of time that the employer's payroll or timekeeping system works in. So I imagine this would be potentially a scenario where somebody had an appointment or foreseeable use, and potentially, let's say the employer had a timekeeping system that tracked time in 10-minute segments, that the person could be out for 2 hours and 20 minutes for a medical appointment. Not sure how common that is going to be, but that is also a provision in the law. All right, let's go to the next one. So the next one is termination, reinstatement, and employer secession. Another common question is, does this mean that when the person leaves their job, we need to pay them out any unused hours? And the answer is no. So that is not a requirement under current law, and this law does not change that. Certainly some employers do pay out PTO or vacation or sick time currently, and this law doesn't prohibit you from continuing to do that. And whether that's paid out all the hours, partial of the hours, dependent on how the person gives notice, whether it's into a health savings fund or a retirement fund, there's lots of different ways that that's addressed. The law doesn't change that, and it doesn't, but it also does not require it. If the person leaves working for you and leaves working for an employer, and then they return within 180 days, their amount of accrual they had when they left would be reinstated. So if I have 30 hours and I stop working at my place of employment, and then something happens and a month later they decide to come back, or maybe it's a kind of a seasonal thing where there's a month off. At that point, my amount would be reinstated that I had when I left. So related to termination, there's a question we get about that reinstatement amount, and that's, what if I had paid out? What if the employer had already paid out that time? What happens? Do I need to reinstate the same time that had been paid out? The answer is no. If it had been paid out, then the employer would not need to reinstate the amount that had been paid out. Employer secession. This is, situation where the employer changes hands, there's a change of ownership. At that point, the employees, if they're retained and they keep working for the same employer within 30 days of that change of ownership, they would also keep their accrual amounts similarly to the reinstatement. Construction collective bargaining agreements. This one is, there's a provision in the law that allows for when there's a construction trade association as well as a construction employer if they have a collective bargaining agreement, they can come to an agreement to waive earned sick and safe time. I don't know enough about that industry, but I believe it's related to kind of the specific way that employees may work for many different employers over a course of time. The last one here is employer attendance policies. So some employers have what's called no fault attendance policies, where somebody might earn a point kind of situation if they are out for any reason, including an allowed reason. This law does prohibit employers from kind of issuing points under those systems to employees that are out, basically kind of in a way not allowing there to be a deterrence from people from using the time. So I know that's an adjustment as well for many employers. Okay, so this is the slide and just sharing a little bit of our resources. This is our main page. I know after these sessions, people tend to have more questions, and that's the main spot where everything will be posted. So dli.mn.gov/sick-leave. FAQs are being updated continuously, but we have a lot posted already. We'll have that sample employee notice, fact sheets. We have resources in multiple languages, if that's helpful for you. And then additionally, there's our phone number and email, and we take many calls and emails from employers every day. And then we have a bulletin to keep up to date on a once a month update. So with that, I think I'm gonna maybe stop sharing and we can run through questions.
Sounds great. There are a number of them. So Dave, you may have to be a little bit rapid fire in your responses. Okay. And you're available to stick around for a few minutes. I'd love to get all these questions answered in the webinar today.
Okay, I can stick around a little later. Yeah.
Okay, let's see how many we can get to. So I'm taking these top to bottom, guys. So with regards to the provision for front loading 80 hours on a calendar year basis, is prorating the 80-hour amount allowed for new hires joining the company after January 1st?
Yeah, that's a question we've had a lot, and there is not a provision to do a partial or a prorated front load. So the law does kind of put forward that if you do front loading, that it would need to be in those amounts of at least 48 or 80. So I understand the question, but it doesn't provide for that. So maybe that's a situation where the employer is doing accrual for that period, or you're adjusting the way that you're going to do your accrual year. So yeah.
Yeah. This is related, and I think you may have somewhat addressed it with regards to part-time without a specific scheduled number of work hours per pay period. Is there a provision to front load hours based on a calendar year, or is the provision under the law for them accrual?
Yeah, it's the same. I guess it's really the same answer. And there's the three options that we walked through, and that's kind of employers figuring out which of those three options work best based on the employee's that individual employee situation. And again, you can use different methods for different sets of employees. So potentially with that part-time employee you're using a different option than you would for your other employees.
Okay. Could you please speak about the rules around an employer's attendance policy application when earned sick and safe time is used?
Sure. So that's the one where the points, if you have that kind of no fault or similar type of situation, the person would not be able to accrue points if they're using this time. This is, I guess, another time to maybe emphasize that the time that we've talked about that falls under the law, so that the employer, you're giving at least 48 hours or 80 if you're front loading in that sense. Those hours fall under the requirements of the law. If the employer is providing more time than that, additional PTO, different vacation plans, etc., employers can certainly have their policies that are different from what falls under this law for that set of hours. So, for example, an attendance policy could apply to those hours.
Okay. This one is about using a couple of different systems. Can we put first-year employees on the accrual system and anyone after year one on the front-loaded system?
All right, quick answer is yes.
Okay. We're gonna have a couple resort-related questions. This is the first one. With regards to resorts and camp counselors who get paid for 3 months in a lump sum, but don't necessarily have hours worked, are they eligible for earned sick and safe time?
If they're employees, if there's an employer relationship, then yes, they would be. I guess I would, that employer could come up with a system to figure out the hourly rate. But the other thing, I guess this brings up another point that I didn't make in the presentation, that I'm not sure how that employer or those types of situations work, but if this person does need to take a day off, but if there's like a payment, that a stipend or a seasonal payment like that, and the employee does take time off and they don't actually lose compensation because they've missed that day, the employer is not going to need to pay them again because they end up taking off. So yes, they would need to allow them to have the time off, but they wouldn't need to additionally compensate them in that situation.
Right. I think I know the answer to this one as well. Can the employee use hours not yet accrued in a given year?
Employers can advance time, but it's not required.
All right. Can the employer determine the earned sick and safe time rate for certain positions? Is there a standard system for computing that rate, or is that even allowable?
If we're talking about the pay rate, which I believe that's what the question would be, then it's kind of what we reviewed before. It's essentially what was the rate or hourly rate they would have earned if they would have worked that shift. And then if they're working in a variable pay rate system, that gets a little more complicated, but employers can kind of create a system to establish a method to calculate what they would have earned based on looking at a last set of pay periods or other employees that worked in that job classification that day. At the end, at least the minimum wage is required for those hours.
I think you addressed this already. Does accrued time need to be paid off if the employee quits or gets fired?
No. It doesn't, no.
Yep. I'm scanning here. Does that mean that as long as our current PTO system is matching the requirements for earned sick and safe time, do we have to provide more? No. Right?
No. And I mean, I think one of the things that I've noticed after a lot of these sessions is that some employers, certainly everybody's in different places, but some people are realizing, okay, well, I really don't need to make that many changes to my plan. We're almost there. So I think, it's going to be dependent on your situation, but some employers' plans or programs are very close to what's already, it's in the law.
I would imagine though, Dave, that the definition of a family member probably would need to be updated in a lot of handbooks and policies, correct?
Yeah, that's something, you know, and as long as you're allowing it, I mean, certain PTO plans say, you know, you can use it for any reason. And so of course, any reason would be caring for any family member. So it's just kind of dependent if the employer wants to go through the full list and kind of list all that out, or just or broaden it out, and that's up to the employer.
Does the pay stub have to specifically indicate Minnesota Sick and Safe Time if they're using their own PTO system?
It does not. It can be any verbiage there. You can call your program anything you like. Yep.
Can an employer have a 90-day probation period before the Minnesota Sick and Safe Time begins?
That one is no. It does start accruing as soon as someone starts their job. Certainly you can have a probationary period for all the other things related to the employment situation, but they would be able to start accruing as soon as they start working.
Does bereavement time is covered under this?
It is not.
Okay. Can an employee only receive sick and safe time for hours scheduled or?
Yes.
Okay.
Yes, that's a yep. So you're not earning for paid holidays, paid, you know, when you're earning sick and safe, you're not earning during those times. You're only earning when you're actually working.
Okay. For option 3, what amount do you need to front load for a new employee? And then can that be prorated if they start mid-year?
Yeah. Again, the proration is not kind of contemplated in the law, but so it would be 80 hours.
Okay. This is another resort related question. Does this apply to J1 visas or H2B work visa employees?
Sure. It would. It's for anybody who's working in the state of Minnesota. There's no immigration status requirements, different types of status, or yeah.
Mm-hmm. If we use our current plan that's more generous, can we designate the first 48 hours that they use to be earned sick and safe leave?
That's a little bit of a kind of a legal question depending on the situation, but I think generally the answer is yes.
Okay. If more than one employee puts in an advance notice for using time, are we allowed to deny so that we are not severely understaffed?
Yeah, I hear that question, but the law does not have that provision in it.
Does someone need to rename their policy, or can it still be called PTO?
It can be called PTO.
I'm just rattling these off, Dave. So
yeah, we're getting through them. It's good.
Can notice of time accrued be in the payroll check, or does it have to be on a pay stub?
Yeah, it does. I know employers have different systems for providing that information, but the law does have the provision that it is on the earnings statement or check stub. It doesn't necessarily need to be. Sometimes there's like a continuation page, I believe it's called, with that, and it could be on a second page, but it is part of the earnings statement.
Okay, I think you addressed this. The people can the hours need to be available to use right away. There's no provision for a probation period, correct?
Correct. So related to that, I mean, the time it accrues, basically employers can have the time accrue when the pay period is kind of when we get to the pay period. So while yes, the law does state that the person can use it as soon as it is accrued, essentially those hours are not going to post or kind of be made available to the employee until the pay period. Then the person, you know, when they start their job, most likely those first pay periods are going to be 1, 2, 3 hours. Certainly certain employees could use that time. I think it's, you know, less likely that somebody would use time initially when they start their job.
Okay, I have 3 more here and then we'll wrap it up. How do you recommend handling hour accruals for salary and commission based workers that don't clock in and out on a standard basis? I think you talked about that earlier.
Yeah, it's so the employer can make a presumption or assumption of a 40-hour work week. You know, salaried exempt employees certainly work more hours often, but it's you can base it on a 40-hour work week.
Okay, that addresses the next question about salary positions.
Okay.
And then the last one is, does this apply to employees that work outside the state, but the company is based in Minnesota?
Yeah, that's another good question. It does not. So this is for people that are working in the state, regardless of where. So the employer could be based out of state, but if you're working in Minnesota, it would apply to you. But if you are working in Wisconsin, even if you're working for Best Buy, it is not going to apply to you.
Okay, I'm gonna sneak in one more. If an employee gets to 48 hours and then uses 8 hours, right, can they then accrue 8 more to get to 48?
So they would not need, the employer would not be required to do that. It's once they get to 48 in that 12-month accrual period, the employer can stop the accrual. Certainly employers could have a more generous plan and that it could keep accruing, but they wouldn't need to do that.
All right, well, that brings us to the end of the webinar. Thank you, Dave, and the Minnesota Department of Labor and Industry for making time for the Brainerd Lakes area today. I'd like to thank our co-hosts, all the area chambers and the Lakes Area Human Resources Association. We will put a number of information and links in the PowerPoint presentation, link to the webinar on our website, BrainerdLakesChamber.com, and check out that page for more FAQs. Thanks a lot, everyone. Have a great day. We'll see you soon.